Hi everyone. So today I'll be answering your questions about mass deportation. I got so many comments on my video on mass deportation that I want to make sure that I am answering your questions and giving you the information that you need. Okay? Just if you're joining me live, make sure to say hi. Welcome. And I am working on going live everywhere. So if you're trying to watch this on Instagram, I'm so sorry. It is just taking its time. But yeah, I'll be answering your questions. I got so many comments as I stated that it just made sense to go live and talk about this. So first thing first. Okay. Just want to make some clarifications. Mass deportation is a process that the Trump administration has stated that they want to use to basically get as many undocumented immigrants out of the US as possible. This is their stated goal for immigration, is to do this mass deportation, and they already have, who they're going to target and how they plan on making their mass deportation dreams a reality. And part of that is detaining as many people as possible and creating detention centers in different states to make it easier for them to detain as many people as possible and to deport as many people as possible. Okay, so that's why that is there. Okay, that's why I am doing this video, to talk about that. So if you have questions about that topic or US immigration in general as it exists today, I have to put that caveat in there, as it exists today. So again, if you have questions about US immigration or questions about mass deportation, feel free to put it in the comments. I am here to answer your questions. And as I'm waiting for you to come in and ask your questions, I will be addressing some of the comments that I received on the mass deportation video. If you have not watched that video, I go into detail about what the Trump administration would be able to do under current US laws. Again, as a lot of people say that in those comments, he may be able to change some of the US laws if he has the full support of the Republican Congress. Okay, that's really important to mention. But until that happens, we are going to operate based on the laws as they exist today. All right. So if you have questions, feel free to put it in the comments. Feel free to say hi and let me know where you're joining me from. All right. So first question I want to address is, first comment is, this person said, illegal is illegal. What do you not understand? I am not aware of levels of illegality. If you're first gen, second tether, and your parents are illegal, GTFO, if you know what that means, birthright citizenship was not meant for you. All right. So this is a comment that I see a lot of people make, where they basically think that if you came to the US, or if your parents came to the US and they are undocumented and they have you in the US, that you should not be able to get citizenship automatically, even though the US Constitution says that anyone that is born on US soil is a US citizen, right? There's no caveat in the Constitution. So if you want that caveat, then the laws need to change. The Constitution needs to change. It needs to be a constitutional amendment. So I just want to make that clear. So if you are not understanding how the laws work, how the Constitution works, that may be your issue there. But as it stands today, anyone born in the US is a US citizen, regardless of the status of their parents, because it's birthright citizenship. Unless the US changes how someone that's born in the US becomes a citizen, that hasn't changed yet. So until that happens, anyone born in the US is a US citizen, regardless of their parents' status. So just want make that very clear. And then other questions I've been getting is people just trying to make sure that they are safe and that they are putting themselves in the best position. And that's where this question is coming from. So my question is this: can someone apply for citizenship with an expired green card, and also green cards that are waived? Are those good anymore? Waived in the sense of when you received it, you were a minor and you didn't have a fingerprint. So if you have an expired green card, you can apply for citizenship. But if it has expired, if it's been more than 2 years since it has expired, I always recommend going ahead and just applying for a renewal, because you will then be able to get an ADIT stamp that will serve as your green card until your citizenship is approved or the green card renewal is approved. So you want to make sure that you constantly have proof of your status. That's really the key here. So can you apply for citizenship with an expired green card? Yes. But for the next few months, you really want to make sure that you have documented proof of your status in the US, especially if you have a green card and that green card has expired. You want to make sure that you have proof of your status so that if anything happens where you may have been stopped by ICE or a government agency, that you have documentation showing that you are a permanent resident of the United States. So yes, you can apply with an expired green card, but please have a documentation that shows you are a permanent resident. And you can do that by filing the renewal and then asking for an ADIT appointment. In that ADIT appointment, they will give you a stamp in your passport that serves as your green card until either you apply for citizenship and become a citizen, or your renewal is approved. So next comment that I want to address is, did you born in USA? So I'm guessing they're asking if I was born in the US. As I have always made clear, I was born in Nigeria. I immigrated to the US, and I've been in the US for over 20 years now. So most of my life I have been in the US, and I am a US citizen. I should make that clear. I am a US citizen, but I was not born in the US, because for some reason that is really important to people. But just putting it out there. All right. So someone's asking, could you talk about the denaturalization of citizenship that is in the plan? So I have a whole video on denaturalization, what the process is and all of that. But a quick breakdown is the US government can try to denaturalize someone that meets certain requirements. So the Trump plan for denaturalization is to review hundreds of thousands, or if not millions, of naturalized citizens, review their immigration file to determine if there's any of them that they feel should be denaturalized, and then to put them in the naturalization process. And the only way to do this is to put them either through federal civil court or federal criminal court. All right, so they can only bring that federal criminal complaint against the person for denaturalization if it's within 10 years of them having their naturalization. If it's beyond that, they will have to do civil. There's a statute of limitation for criminal court, but there's no statute of limitation for civil court. And that's really the important thing here, is that they can try to denaturalize someone that got their citizenship 20 years ago through the civil court process. All right. This is not immigration court. Okay. It's not the Trump administration deciding that someone should be denaturalized, putting them through immigration court proceedings by judges that they appointed, and then getting them denaturalized. No, they have to go through federal rules of civil procedure, the federal court, And as much as people do not have faith in the federal court system or in the court system in general, I still believe that there are judges out there that still believe in the rule of law and that will uphold the rule of law, and hold the US government to their burden of proof. Okay, that's really important because in order to denaturalize someone, you have to, in criminal court, you have to prove it beyond a reasonable doubt. Okay, beyond a reasonable doubt that they meet the requirements for denaturalization. It's not just a hunch. You have to have evidence for everything that you're saying. And it can be a jury trial in federal, in criminal court. So it's really important that although they're talking about denaturalization, that we do not get too scared. It's a whole process. It's not a one day, okay, everyone on this list is now denaturalized. No, they have to go through court. They have to pay attorneys, right? The government attorneys have to be paid. They have to put resources behind denaturalization. So right now it's just talk until they actually put the funding behind all these processes that they want to do. It is just talk. So for mass deportation as well, in order to actually do mass deportation the way that the Trump administration has talked about it, they have to put money behind it. Okay, that's millions and millions of dollars that they have to put in having the personnel that will actually process everyone, having the detention centers, all of those things. So just know it is not, it's not going to be a quick process. The things that they can do, right? The things that they can do is expedited removal, which is where they will, if you've been in the US for less than 2 years, and they can, if you can't prove that you've been in the US for more than 2 years and they put you in expedited removal proceedings, that means you do not go in front of an immigration judge. It is all done with ICE. So it is really, really important. Oh, someone does not want me to go live. Please let me know in the comments if you can still hear me, because I know you may not be able to see me. Oh, no. Holy schmartsies. Okay. Hey y'all. So sorry. Not sure what happened there. Honestly. Not really sure what happened there. We were fine, we were grooving, and then everything just shut off. So this is going to be a little different, okay? Again, I'm really sorry if you join me and things went off. Just know sometimes that happens when you're live and it is not on purpose. Okay. If you are still here and you can hear me, please just let me know in the comments that you can hear me and see me. Um, and then we can continue. All right. So I was before we were rudely interrupted by things just shutting down over here. I was talking about the how um, the Trump administration may be able to make their mass deportation happen. It's not going to be by just deporting a bunch of people. They will need to find the people and then, right? So one, they have to find the people, and then two, they will need to then go through the process of either putting them in immigration court proceedings or by doing something called expedited removal. So expedited removal is a process where the US government does not need to go through immigration court. They can kind of skip some of those requirements. So immigration court process is very specific. In the Immigration Naturalization Act, there's actual process that needs to go through. There's immigration judges. There's an appeal process in immigration court. But if the US government decides to go the other route and they're able to make the argument that the person fits into the requirements for expedited removal, now they can take it a step further where they can skip immigration court completely and go straight into the deportation process and actually remove the person as quickly as possible. So anyone in the US for less than 2 years is in that window for expedited removal. However, if you are already in immigration court proceedings, it is going to be very hard for the government to argue that you are also in the process for expedited removal, because again, in order to do that, it's one or the other. It's either you're in immigration court or you're in expedited removal. Okay, they can't kind of pick and choose, right? So if you are already in immigration court process, they basically have to put you through that process and not then take you out of that process to do expedited removal. All right. So that's really important. I know a lot of people were scared about that and wondering if they would still be able to remain in the US while their case is pending, or if they will end up having to go through that expedited process. And so really, really important here that we know the difference there. Remember, if you have questions, please put them in the comments. I am literally here just to answer your questions and to make sure that you don't leave here with more questions than answers. All right. So make sure to put those in the comments. And then if I don't see any questions, I'll just keep talking about the comments that I have been receiving on the mass deportation videos, because like I said earlier, there were a lot of comments, and it can be interesting to see where people are with the whole process. What is the most important thing to people while they're talking about this? All right. Someone here is asking, what if they have a baby in the US and I'm guessing the baby, and they've been in the US for 6 years. So having a child, again, another misconception, having a child in the US does not automatically mean you get to stay in the US. Okay, it does not. So if your child is over the age of 21, like 21 and older, and they can show that they can support you, then your child will be able to file an immigrant petition for you. And then you may be able to adjust your status if you entered with a visa or you entered with parole. If you did not have a legal entry into the US, it does not matter, right? I really want to make this clear. If you did not have a legal entry into the US, it does not matter if your child is a US citizen that's over the age of 21, because you are going to end up needing a waiver. However, if your child is in the military and they do something called military parole in place for you, that will give you the legal entry to then be able to adjust your status. But if you don't have a legal entry, that means you're going to need a 601A waiver, and your child is not a qualifying relative for that waiver. Only a US citizen or permanent resident parent or spouse can be a qualifying relative. So when people talk about, oh, they come to the, that undocumented immigrants come to the US, have children, and it's like this derogatory anchor baby argument, it's just ridiculous, because we know how hard it is. You have to literally come to the US with the intentions of having this baby that will eventually file for you, knowing that you have to wait 21 years for that plan to actually work. There's not many people that have that plan when they come to the US. So it's one of those things that I really want people to understand, that that's not how it works. Okay, that is not how it works, but people will always talk about it that way. Oh, hi, Tammy. Thank you for joining me. Thank you. So this is a different camera view and mic setup because my normal setup shut down on me mid recording. So just bear with me today, okay? Just bear with me on this view today. All right. If you have questions, please put them in the comments. Like I said before, I'm here to answer your questions and to help as much as I can, knowing how much, as immigrants, a lot of immigrants, and I deal with a lot of immigrants, how scary this whole process can be. So feel free to ask me questions. All right. Blessed Girl asks, I got my 10-year green card through my spouse. How often can I travel without her? My son is also a resident and he loves to go in the Navy. What's your advice? How often can you travel without your spouse? There's no requirement that you travel with your spouse. I don't know if that makes sense. So when you have your permanent residency, you do have a requirement for the US to be your permanent home. That's the requirement that you have. There's no actual requirement for you to then travel, that every single time you travel outside of the US, you have to travel with your spouse. That is not a requirement. As far as your son joining the Navy, he's a resident. So if he's a permanent resident, he can join the military. He will need to reach out to recruiters and start that process with them. Once he is accepted and he goes through the training, they can talk to him about getting his citizenship through his service. So, and those are typically done super quick, okay? And they would just make sure he qualifies for it. But he will need to basically apply, talk to recruiters for the Navy or for the military in general. And then depending on, his skills and what he qualifies for while he's in training, he may qualify to join the Navy and go through that training process. But the first step is to talk to recruiters as far as that's concerned. Tammy's asking, please, can someone travel outside with parole based on the VAWA case without problems? So if you have advanced parole, you can travel outside of the US. My recommendation right now to almost everyone that talks to me about traveling is to travel and come back before January 20th. actually January 17th, just to give yourself enough time in case there's any delays or anything like that. All right. But when it comes to coming back into the US, the parole is really, that's all it's for. The officer at the airport will still have to look at your process and just make sure that the parole is still valid and all of that. But would you be able to come back on parole? That's the purpose of the parole. There's always a risk. Like, I will be honest with you, when you're traveling on parole, there's always a risk that you will get that officer that gives you a very hard time. However, there's still that purpose behind you having the parole, which is for you to be able to travel. Again, if you're planning on traveling, please be back in the US before the 20th of January, because we don't know what day one would look like. That's really the key here. Because we don't know what day one of the Trump administration will look like for immigration, we want to make sure that everyone that is in the US or that travels outside of the US with parole, or that needs to travel to the US with a visa, is coming into the US before that date, because again, his supporters are saying that he's going to declare a state of emergency. If that does happen, again, we don't know, right? But if that does happen and you're outside of the US and you only have the advanced parole or you only have a visa to the US, it may make it significantly harder for you to come back into the US. So just make sure your trips are between now and the 17th, just to be on the safe side. Ricardo is asking, what should I do if my wife do not have a 2023 transcript for my immigration case? It depends. So the question is, did she file a tax return? And if she didn't file a tax return, was she required to file one? Okay, that's the key. So if she's doing like an affidavit of support for you and she is required to file a tax return and she didn't file one, she can still file one. If she did file a tax return and you're just asking about the transcript itself, you can request the transcript online on the IRS website. So there's two ways to do it. You can request it and have them mail you the transcript, or you can create an IRS online account and all her transcripts will be on there for her. If she was not required to file a tax return, then you would not have wow, I can't speak. If she was not required to file a tax return, you would not have a transcript to give, right? So then the question is, does she have income that does not require her to file a tax return? Or is it a situation where she has no income and you're going to need a joint sponsor? So those are the things that, I typically will go through with people and figure out what is the issue? Do we need this joint sponsor, or is it just getting the transcript? If it's just getting the transcript, you can get it on the IRS website. It typically takes them like 5 days to get it to you. They're really good with sending it as quickly as possible. So if you just need the transcript, just order it. You'll get it quickly, and there's no fee. I know I say like order it, but there's no fee. They will just mail it to you, or mail it to her, I should say. Okay. All right. So if you have advanced parole and you had an asylum case that was, I'm guessing, dismissed or terminated by the court, is it safe to travel with parole? Again, when it comes to traveling on advanced parole, there's nothing like 100% safe. Okay, I will always make that clear. There's nothing like 100% safe when you're traveling on advanced parole. The officer at the airport will still need to make the decision to admit you on that parole. So just keep that in mind. But typically the people that will have a higher issue are people that are in active immigration court proceedings and active criminal cases, right? So just know that. those are the ones that will have the highest, the greater chance of having an issue at the airport. But people travel all the time on advance parole. It's just dependent on your background. You may have a higher risk than someone else that has that has nothing on their background that will make it negative for them at the airport. All right. So Manny is asking, what can you tell us about that crazy idea of using the military to deport undocumented immigrants? Well, so when they say the military, they mean the National Guard, right? So typically it's not Army operating inside the US, it's the National Guard. Can the president bring the National Guard into immigration matters? Yes. Have they done it before? Yes. Okay. So it's not unheard of. So it is absolutely possible. The question is always going to be, how logistically do they deport that many people? How logistically do they detain that many people? Because it's going to be millions of dollars to fly them outside of the US, because they can't just drop them off in Mexico, right? Or any country that has a border with the US, unless they're actually from that country. So that's something to keep in mind. So if you're saying that the person is a citizen of, let's say, Nigeria, and you want to deport them to Nigeria, guess what you have to do, right? If you want to physically deport them, yes, the military can help you in the sense of detaining people. That's really what they're talking about when they talk about military being involved. It's more of the detention of people. But actual deportation, getting the person outside of the US, requires flights. All right, it requires flights to those countries. And if you're deporting millions and millions of people, that's a whole lot of flights and that's a whole lot of money. So they will need to figure that out. But as far as using the military, it is not unheard of. It has been done in the past. The presidents have asked the National Guard to get involved in different situations, as far as like crowd control or getting people to where the government wants them to be, which is what I would suspect would be the main thing that the military will be doing, is just detention and running those detention centers. All right. Next question. If you have a spouse that tricked you into sponsoring him and he has been working under your social security through DoorDash, but then you found out he has been lying about other things, what should you do? So that seems more like trick you into sponsoring him. So I'm not sure what you should do. Because I don't really give advice on what people should and shouldn't do. It's more of what can you do, right? So I want to make that clear. It's more of what can you do versus what should you do. That's all I'm telling you on these videos, is what can you do, not what you should do. So it depends on the stage of your process. If the final process is not done yet, as the petitioner, you may be able to withdraw your petition. If the person already has their permanent residency, there's not really much you can do as far as withdrawing your petition is concerned. Typically, when people ask me this question, I just direct them to USCIS, because that they will give you more detail on what they would want if they want to do anything about it. And then it's up to them to decide whether there's enough there to act on it or not. So that would be my advice, I guess, would be you can check with USCIS and see, depending on your process, if you want to stop the process, if it's not completed. This is something I always tell petitioners. So in my practice, I represent petitioners and beneficiaries. Okay, so that means if there's a spouse coming to me, I'm representing both parties, not just one. So when you're coming to me and you're giving me information or you're asking me things, just know, and I make this clear, your spouse has every right to know the information that you're giving me. There's no secrecy in this because I'm representing both of you. So when it comes to that, it's always important that that is made clear on who the lawyer is representing. But as far as how it usually works in my practice, when there becomes an issue where one spouse does not want to move forward with the petition, I have to withdraw from the case because of the rules of ethics. All right. Lawyers are covered by ethics. So if I'm representing both of you and then there's an ethical issue where one person wants to withdraw the case and the other person wants me to get involved in asking the other one to stay in the case, that's not my job. Okay. My job is to get both of you to your end goal. And if that goal changes in the middle of the petition, I cannot be involved in that process anymore. Because again, I'm not a marriage counselor. I am not involved in your marital issues. But as far as like the petitions are concerned, that's where I can assist you. But attorneys, we can't, like, if we're representing both sides, we can't take sides. That's kind of how that works. So in marriage cases in my firm, we represent both sides. We don't take sides. And if there's issues, we put a pause on the case until those issues are brought back to us and said, okay, we have resolved our issues and we want to move forward. And we need to hear it from both parties before we move forward. So that's just how we handle things here. Can a U.S. citizen living in the States file for N600K for his 12-year-old son, green card holder, who stay in school abroad? Thank you. Okay. Just want to make sure I understand. Is there a reason that they cannot move to the, so if there's no intention of the child moving to the US, then an N600K, if you meet the requirements for the N600K, yes. So basically the purpose of the N600K is to make it possible for the child to get citizenship without physically living in the US. Okay. So if you meet the requirements and your child meets the requirements for the N600K, then yes, you can do that process. Just know eventually for the interview, they will need to physically come into the US to go to the USCIS interview. But beyond that, yes, you can go through that process. Okay. So Ricardo actually basically followed up on his previous questions about the tax transcripts. She has no income for 2023. So typically, if the person does not have income for the year, they are not required to file a tax return. So, so if they're not required to file a tax return, then you can just indicate that on the form. So on the I-864, it does have a section where it asks, what's the person not required to file? You can check off that box, right? As long as they were not required to file. And if you have a joint sponsor for the affidavit of support, then it doesn't really matter what their income is anyway. So, but you still have to fill out an affidavit of support form for your spouse and your joint sponsor. So just keep that in mind. Okay. So going back to the question about the spouse that may have tricked their spouse into marriage and sponsorship, she tried to withdraw the I-864. Yeah, again, it depends on if they already have the status. That's really the key. If the case is still open, then the affidavit of support or the I-485. I think you just flip that. So if the case is still open, the I-485, the spouse filing for the I-485 is the immigrant, not the spouse that's a U.S. citizen, just to make that clear. So you cannot withdraw the I-485. So if the I-130 is already approved, it's harder to get things undone. So the I-485 cannot be withdrawn by the U.S. citizen. It can only be withdrawn by the immigrant looking to get the green card. If you're saying the I-864, that's the affidavit of support, that can only be withdrawn if the green card application has not been approved or the immigrant visa has not been approved. So, but once those are approved, there's no more withdrawing the I-864. All right. Next question. I came in the US with F1 student and I lost it. I applied for asylum and I have already got my EAD and my asylum case is still pending. Do I worry about deportation? So we don't know. You know, I know some people will be like yes or no, but I'm always going to be honest with anyone that asks me a question, and the answer is I don't know if you need to worry about it. However, what I can tell you is with the current laws as they are, when you file an asylum application, if you look on your receipt notice, it says that you are allowed to remain in the US while your asylum application is pending. Okay, it says that on your receipt notice. So you can stay in the US while your asylum application is pending. So because of that, so we kind of look at, things in the law to kind of say what can happen. So because the asylum application, the receipt notice for that specifically says that anyone that applies for asylum, because you have this receipt notice and we have received your asylum application, you can remain in the US while your case is pending. For that reason, right? For that reason, I do not believe that you would be, you have a lot to worry about as long as there's no other issues, right? Have to always put that caveat. So people with pending asylum applications typically do not have to worry about, being removed before their asylum case is decided. So that's why they specifically say on that you can stay in the US. What I typically am recommending to people right now is to have a copy of your receipt notice with you. Especially starting on January 20th, you want to just have a copy of your receipt notice or something that you can easily pull up that shows that your case is pending. Okay, that's really, really important moving forward, because if you have a case pending, you are less of a priority, right? I always tell people this, in the first Trump administration, I was still doing my law stuff, right? I was still representing clients and doing all of that. So in the first Trump administration, I actually had a client, we just filed their green card application. And then a couple weeks after that, they get a knock on the door, and guess who it was? ICE, because they overstayed their visa. So ICE is knocking on their door, wanting to detain them. And my client, being smart, because I always tell them what to do, went ahead and told the officer, hey, I have a lawyer. I have a green card application already pending. We already filed. And guess what? The ICE officer gave my client their card. I called the officer, sent over the receipt number for the officer. They checked it, saw that there was a case pending, and they left my client alone. So having a case pending that you qualify for really does help when it comes to ICE and all of that. All right. All right, so next question. If they get a social security card and a work authorization before they get an interview, is that a green card? So that is So the work permit is an application that's based on having a green card application pending. Again, you must have filed an I-130 unless it was like a fiance case, right? A fiance visa case. There must have been an I-130 that you filed. So the I-485 you cannot withdraw because that's his application. You can only withdraw applications that you filed. So you may need to look at what did you file and if it's still pending. And then that's what you can kind of withdraw if you want to withdraw. Josh is asking, daughter who is U.S. citizen turned 21. She filed I-130 a year ago, still waiting for it to be approved. In the meantime, she met a guy with a green card and they got married. Okay. Question, the new husband who's a green card holder should file for another I-130 petition for her, or the one that her daughter filed would be enough? Okay, and make sure I understand before I answer. Okay, so I think I understand. The parent, right, the mother is in the US and the daughter turned 21 and filed an I-130 for the mother. Then the mother married someone that's a green card holder. So should the new husband also file an I-130 for the mother? So here's the thing. Because the husband is a green card holder, the mother, so his wife, who's the mother in this situation, is not an immediate relative. And if she's already out of status, she cannot get a green card through the husband unless the husband becomes a US citizen. Okay, so even if the husband files an I-130 for her, she will not be able to adjust her status unless she is currently in status when that application is filed, when that green card application is filed. The daughter, though, is a US citizen, and the mother is considered an immediate relative of a US citizen, right? Because the daughter is a US citizen. So as long as she entered with either inspection or parole, the daughter that's 21 that's filing for her, that's a US citizen, will be able to file for her, and she will be able to adjust her status and get a green card without needing a waiver and without having to leave the US. So having a US, being an immediate relative of a US citizen is much, much better than being having a permanent resident spouse or child or any of that. Immediate relative of US citizens get a priority over everyone else. Okay, Ricardo, just quick. I know you're asking about the affidavit of support. Even if you have a joint sponsor for your affidavit of support, your petitioner must still file an affidavit of support. And their affidavit of support will basically say, hey, I don't have any income, right? That's what theirs is going to say. And then your joint sponsors will say, hey, I have this income and I'm able to support this person. So it's really important that you get that, because I've seen that happen where people file without, with a joint sponsor and forget to put an affidavit of support for the petitioner. So the petitioner still needs to file an affidavit of support, even if they don't have enough income or no income. Okay, really important. All right, she came uninspected. Ooh, okay. So then forget everything I just said. So she came into the US without inspection and without parole. The daughter's petition will still be faster than the husband's, so the I-130 will still be faster. The husband can be the basis of the 601A waiver, and then once the I-130 is approved, she can file a 601A waiver based on the husband, right? It's a whole process. And then once that 601A waiver is approved based on extreme hardship to the husband, Then she can leave the US for her interview at the embassy based on the daughter's I-130 and be able to come back into the US based on that I-130. So if it's been pending for a year, it's going to be faster to just continue with the daughter's petition and then file a 601A waiver based on extreme hardship to the husband. Because before she got married, she did not have a qualifying relative for the waiver. So she's in a good position. She should probably like consult with a lawyer just to make sure that every single detail is good as far as getting the waiver and all of that. But she's in a better position than someone that just has a US citizen child and came in unexpected. All right. Is your work permit enough evidence to walk with? It depends on what the work permit is based on. Because, okay, so here's the thing. I always have to kind of reel it back. So if you have a green card application pending, you file a work permit application, your work permit is approved, and then let's say 6 months later, your green card application is denied, you still have your work permit that has an approved, that has it's approved from this date to this date, and that date may be 2 years from now. So they can still argue that they're not sure if your green card application is still pending or not. So you just want to make sure you have at least at the minimum, the receipt number for your application. Whatever that petition is, whatever, if it's asylum, if it's a green card application, whatever it is, you just want to make sure that you, at a minimum, have the receipt number, if not a copy of the receipt notice. Okay, is it possible for me to file N-600K for an adopted child? No, no, I'm sorry. In order for you to file for an adopted child, you need to figure out if they are in a Hague Convention country, because if they're in a Hague Convention country and you already completed the adoption, it's going to be far harder for you to complete the process. If they are not in a Hague Convention country, then you would need to go through either the Orphan process or the I-130 process. The Orphan process requires them to either have one or both parents that are deceased, or that abandoned them. There's specific language, but it's not just having parents that are dead equals orphan. It's more if the person is abandoned by one or both parents, and the other parent that's still there is not able to care for them, they will still be considered an orphan for immigration purposes. You will need to go through all of those applications. And it's key to know that, you will need to go through that for them to then be able to get a green card and come to the US. The N-600K is for biological children. Okay, unfortunately, that's what it is. Because the US government will still need to figure out if you have met the requirements for adoption before you can then get citizenship for that child. So technically, an adopted child, unless the adoption took place in the US, the child can only get citizenship through the parent if they got a green card based on the adoption and came into the US and then file an N-600. But an N-600K does not work for adopted children. Okay, so if you have any more questions, please feel free to put them in the comments. Hi, Pierre, thank you for joining me. If you have not liked this video already, please go ahead and do so. And as always, if you would like to schedule a consultation with me, you can definitely do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. And just know, if you want to, the fastest way to book a time with me, because people ask me this all the time, is to go on the website, go on Contact Us, and you will actually see my availability right there on the website and be able to schedule a consultation right on the website. And then we do represent clients in all 50 states with this caveat. If you want a lawyer that is local to you, right, and you're not in Massachusetts, then I may not be the lawyer for you. If you are okay working with me virtually, um, I am okay working with people from all over the country. I have worked with people outside of the US as well. So it doesn't, for me, it doesn't matter where you are, I'm still able to help you. And we're able to at least schedule the strategy session, make sure I'm able to help you, and then figure out what the next steps are going to be. All right. So, okay. So with the withdrawing, feel free to schedule a strategy session. With the annulment, you will need a divorce attorney in New York. Okay. So I can do immigration all over the world and all of the US immigration all over the world and all of the US. But when it comes to like divorce cases, the state specific cases, I have to be licensed in that state. Immigration is federal law. So it's the same everywhere you go, basically. All right. So if anyone has any other questions, please put them in the comments, please, and thank you. All right. And then, all right, so I want to cover this comment because it is one of those that I don't want people to be scared because people will say this a lot, especially with the mass deportation. And let's just get to the comment. The Aliens Enemies Act is actually the Alien Enemies Act, and national emergency will void all of this for illegals. Read how past presidents used the Alien Enemies Act before. Honestly, with Republicans in House and Senate, the law and policy can be changed in Trump's favor. Leave and do it right or be banned 20 years. Okay. So I wanted to read that comment because people love this act because they think with this act, the Alien Enemies Act, that it just gives the president all these rights, which it does, but only in times of war, a declared war, and Congress declares war. And yes, in January, they will have House and Senate, but if he keeps appointing House Republicans to cabinet positions, that may not happen, right? The margin between the House Republicans and House Democrats are getting smaller as he keeps appointing House Republicans to cabinet positions. So it's going to need every single Republican to vote yes, basically, on any of these things. So that's really, really important there. And in order to declare war, you have to specify the country that you're declaring war on, right? To use this specific act, you need to declare war on a specific country. It's not, we're declaring war on immigrants. Okay, that does not qualify for the Alien Enemies Act to be activated. So as much as people want him to have that, he will need to convince all of Congress that this is the way to go, at least the Republicans, all Republican Congress people, basically. So, and the Alien Enemies Act has only been activated 3 times, and it was all during significant wars. So we will see what he ends up doing. The state of emergency, the national state of emergency, is more likely than the Alien Enemies Act being used. But again, there's processes, there's things that need to be done and proven to make that happen, basically. But we will see, and I'll bring you those as they come up. Hopefully there's not a lot that happens quickly, but there will be lawsuits. I will say that. So everything that he does, there will be lawsuits, and hopefully we win some of those lawsuits, right? All right. Um, next question. What is a public charge if I am a US citizen and have public assistance because of disability? So the public charge rule is more about the immigrant. So it's not about US citizens being public charges. It's about whether the non-US citizen will become a public charge. So will they end up applying for government assistance themselves? So US citizens are not subject to the public charge rule. Want to make that clear. So every time they talk about that, it's really about the immigrant, whether they will end up needing public assistance, and making sure that there's either an affidavit of support or that they can be self-sufficient so that they wouldn't need government assistance. All right, next question. Do you take cases like 601A waivers? Yes, absolutely. We actually have a few pending, and we have a client going out for their interview soon. So yeah, wish us luck. But yes, we do handle those. What can you do for someone who have been here 8 years and his spouse is not a US citizen yet? So then I would say if the spouse is not a US citizen yet, but they're a green card holder, you can at a minimum, right? At a minimum, do an I-130, have that pending, so that when they do become a US citizen, you can just apply for the green card. So that's what we would typically start with, is just at a minimum have an I-130 pending. And then as far as what else, it will depend on if there's anything else you could potentially qualify for. We typically do a detailed consultation so that we can kind of figure out what you may qualify for beyond just filing through your spouse. But at a minimum, just based on your question, an I-130 would be just a minimum that you can do right now to just have that pending, so that, and making sure that they apply for citizenship as soon as they qualify. I'm not sure how long they still have to wait to become a citizen, but don't delay that process. But if you have an I-130 already pending, then you can kind of move quickly once they become a US citizen. Yeah. Temi, yes. Unfortunately, we are right now being booked into January. What I am telling people is go ahead and schedule the consultation, and then send us an email if we have cancellations or if we have any additional openings that come up. We typically go first to people that already have a scheduled appointment and offer them those slots. So just know that's the way we handle those. But yeah, we are booked to January, and then we had some slots open up and we were able to move people out of the January date, which is why there's more open in January now. But just schedule and then send an email asking for a soon appointment so we can put you on the list to basically follow up if we have any cancellations. All right. Okay. So Mohammed, what are the countries that are eligible for adoption, or what the website to find those countries if I can find my country there? So every single country is eligible for the adoption process. The question is whether they are a signatory to the Hague Conventions when it comes to adoption. That's the difference. If you want to tell me your country, and if I can think about it, I may be able to tell you if it's part of it. But just know, you can just search, you can Google search your country and just say, for example, Nigeria. Is Nigeria part of the Hague Conventions when it comes to adoption, right? And they will be able to tell you that. The Department of State website also has a list of countries that are part of the Hague Convention when it comes to adoptions as well. Okay, so if you are calling our office now, we do have a lot of calls coming in. So, but we will call you back. I am so sorry, but we will call you back. Okay, just making sure I'm not missing anything. Okay. All right. So I think, okay. So I messaged you before. My wife filed the I-130 August of 2023, and it got approved a few days ago. Oh my goodness. Congratulations. I know it was either the last live or the one before that. We were talking about how long is that taking, and I said it was like 15 and a half months. So yours was pretty much around that. So what I've been telling people is like, right now it's literally between a year and a half for the I-130s for spouses of US citizens. So yeah, congratulations. At least that step is done and you can kind of move forward to the MVC stage and get all your visa petition and affidavit of support done and just wait for your interview. So congratulations. Thank you for updating me. Oh, thank you so much. Thank you for updating me as always. And if you all come here, ask me questions, and then follow through on some of the things we talk about, and it works out for you, please come back and say hi and tell me about it. I really do appreciate hearing it because it just makes me want to do more of these because, again, answering your questions, actually, I like it. I prefer it. How long does I-360 approval takes? It depends if it's based on VAWA. So the I-360 form, you need to be specific. Okay, that form can be used for so many different application types that I need to know which one you're talking about. If it's the VAWA, those are taking about 3 to 4 years for the VAWA applications to be approved. If you're talking about I-360 based on the widow or widower, those are taking about a year. So if it's, okay, so you said VAWA, 3 to 4 years is the average that we're seeing right now. However, if there's a reason to expedite the case, it does not hurt to go ahead and file an expedite. All right. The worst case scenario with the expedite request is they say no, and then you're still in the same position. So it doesn't hurt to expedite your case if you qualify for it. It doesn't hurt to expedite your case if you qualify for an expedite. I don't know what happened. Can you hear me? Oop. All right. So my mic just went out. So if you can hear me, just let me know. And I'll keep talking. I'll just have to speak louder. 1 second. I have another one because, mics go out sometimes. All right. And we're back. Sorry, guys. I have to have a lot of technical issues going on today. Okay. Perfect. Thank you so much. All right. So, Mohammed, you checked, and Sierra Leone is not part of the Hague Convention. That makes your life easier. I will tell you that. That will make your life a little easier. What can I do or where can I start? So, typically, I'm guessing you have no interest in living in Sierra Leone with your adopted child for 2 years, right? That's let's just assume that you are not going to go there and live for 2 years. So your option is the orphan process. Okay, you need to basically determine if you qualify or if the child can be classified as an orphan first. And if they can be classified as an orphan, you then want to go through the orphan process. Typically starts with a home study. You may want to contact an adoption service provider that is authorized by USCIS. That's really important. Okay, not every single adoption service provider is authorized to operate by USCIS. So you want to start there because they have to do a home study. You have to file certain forms to be authorized to adopt. So there's two things that need to happen. You need to be authorized to adopt, and the child needs to be qualified as an orphan. So that's where you start. Once those two applications are approved, then it goes over to the embassy where you can start that process to basically have the child come to the US. But that is your next step, is to find an adoption service provider and go through that. Right. Let's see. Is there a way you can be legal after being here for 8 years without getting married to a US citizen? I actually, great question. I actually posted a video on Tuesday where I talk about ways to get, you can get a green card without being married to a US citizen. So go ahead and watch those videos, but I'll give you like a quick recap. So the options are limited, right? The options are very limited if you have overstayed your visa. So if you've been here for 8 years, you're not in current legal status. So there's asylum, T visa, U visa, and then if you qualify for a 245I, there's that option, but that's kind of, again, it's limited without without being an immediate relative of a US citizen. Your options are very limited. So you can watch that video to just get more detail on those 4 things and see if any of them could potentially work for you, and then explore those options. What's the requirement for a joint sponsor marriage green card case? For a joint sponsor, right? In my office, our requirement is that married, well, lost my thought there. So a joint sponsor for a marriage-based green card case must be either a US citizen or a permanent resident, right? They have to, of course, disclose all their income. They have to have tax returns for the past 3 years. They have to be currently employed, right? They have to have income, basically, that meets the requirement, depending on their household size. So it's really important. That household size part is really important because that's going to determine how much income they actually need to have in order to be a sponsor. So make sure that they have enough income and that they're either a US citizen or a permanent resident, and they're willing to do the affidavit of support because it's a commitment until the person either becomes a US citizen, has 40 credit hours, which is like 10 years of work in the US. So it's a 40 credit quarters. I'm like 40 credit hours, no, quarters in the US. Can a non-immigrant adopt in the USA? It depends on who they're adopting and what their state says about it. Yeah, it depends. And who they're adopting as well. If they, so let me put it this way. There's this whole thing where people may want to adopt someone to eventually have an immigration basis, but the adoption has to take place before the child is 16, or it doesn't count for immigration purposes. But you need to talk to your state courts about whether you can adopt, because they may have certain requirements. All right. So, because I know like DCF here, they do a lot of background checks, and they want to make sure that if you are going to adopt, that the child is not going to end up being in any sort of situation that they're not aware of. So they will ask about your immigration history when it comes to adoption. Okay, so Mohammed, the question, yes, So even though the child has a one deceased parent, the question is, what about the other parent, right? The mother died at giving birth, but what about the father, right? Is the father active in the child's life? Then they may not be considered an orphan. So it just depends, okay? That's why I say it's really detail specific when it comes to adoption, and you want to do it right, because I've seen cases where they're not done right and the child never comes to the US. So it's really important. So we will give you a call back. So if you're calling, and we're not answering, it's probably because we are swamped with calls, but go ahead and just leave a voicemail and we will give you a call back. So you don't have to keep calling. We will call you. And then if you want to schedule an appointment, you can also go on my website and see the dates and times that I'm available, and you can schedule without calling. Okay. That's what that's why I have it available on the website, so that you don't even have to call to schedule an appointment. You can just go ahead on the website and schedule your own appointment, see what works for you, see when I'm available, and schedule that appointment. When you schedule consultations, you are going to be speaking with me. So just know that on the consultation date. But if you're calling the office, you're going to be speaking with my assistant. All right. So the website is on the bottom of the screen. So it's lilylegal.com. And then if you want to, and then click on contact us on that page, on the contact us page, you'll be able to see my calendar. All right. Sam is asking, a person with a terminated asylum case and living in the US for 10 years should be fine. Can they start applying for a green card? Wait a little to see how things are going to be. All right. Let me make sure I understand. So you had a asylum case that was terminated. So you don't have an asylum currently pending. You don't have an asylum application currently pending. The person has been in the US for 10 years. So being in the US for 10 years does not give you status. I want to make that extremely clear. Having a terminated asylum case, unless you're saying the person won asylum in court, but if it's just that the court terminated the case, dismissed the case against them, it just means that the court dismissed the case. It doesn't mean that the government cannot come back and put the person back in immigration court proceedings. So want to make that clear. And typically when your case is terminated in court, you're able to apply for asylum with USCIS. Can they start applying for a green card? Again, it depends on if they were approved asylum in court. So when you say terminated, it can mean a couple things. If they won their asylum case, right? If they won their asylum case, they are an asylee. They have a status in the US. They can apply for a green card. The green card only requires physical presence of 1 year before applying for a green card. So that person, if they won asylum and they've been in the US for 10 years, they should probably apply for a green card. The case was dismissed. So the case being dismissed does not give you status to apply for a green card. If they have other means of applying for a green card, then they should go ahead. If they have other means of applying for a green card, then they should apply for a green card, because right now they do not have an asylum case pending, and being in the US for 10 years does not really give you a status unless you're in immigration court and you file for cancellation of removal. If you have a US citizen or permanent residence, child, spouse, or parents that will suffer exceptional hardship if you were deported. So it's really important to pay attention to that part. So just because you've been here for a certain amount of years, in of itself does not give you status. You have to apply for something. Okay, there has to be a petition that you're applying for that gets you that status. All right. Okay, so if there's, okay, we're getting deeper into this. So here's the thing. If the child is your child, you just need to do a DNA test to confirm it. And if you do a DNA test and confirm that the child is your child, you don't have to do an adoption because the child is yours. You can just file a petition for your child. Okay. So that's kind of, yeah. Thanks for clarifying that. So if the child is your child and you do a DNA test and it proves that the child is yours, you can just file for the child as your child. Okay. There's no need to do an adoption. There's no need to go through the orphan process. There's no need for all of that. As long as you do the DNA test and it shows that the child is truly yours, just go through the normal I-130 process. There's no need for an adoption. Okay? I hope that helps. I hope that helps. You only need an adoption if the child is not biologically yours. Oh, then you need an adoption. Yeah, so if that's the case, then you definitely need an adoption in order to make it happen. If the child's father is unknown, then you and the mother passed away, you may qualify for the orphan process. You just have to go through the process of designating the child through USCIS as an orphan and then designating yourself as approved to adopt through USCIS. So, yeah, then that's the process you'll go through is the orphan process. All right. Thanks for the clarification. All right. So, we've been going for an hour and 22, even though I had some technical issues. Thank y'all so much for joining me. If you have questions, as always, put it in the comments. I'm so glad I was able to answer a lot of your questions. You guys had some amazing, amazing questions today. And I know someone's going to watch this on the replay and get so much out of it. Your questions matter. And there's people out there that are too scared to ask questions here. So just know you are giving value to people by just being here and just asking questions. And thank you so much for joining me. As always, we're probably going to be doing these Q&As for the rest of the year. So these Fridays are going to just be Q&As for the rest of the year to just make sure we're getting to your questions and getting you as much information as possible. All right. Oh, and before I go, because completely just came in my mind. If you are filing a green card application, if you have not sent in your green card application yet, please, USCIS just updated their policy. You must include a medical exam. Okay, so when you're filing your green card application, your I-485, before you're able to file it, and then later on, USCIS will ask you for the medical, or you will take the medical to the interview. Now they want you to send it with the green card application. If you do not send it with the green card application, they will, well, they say may. We haven't seen them deny one yet or reject one yet, but they can reject your application and send it back to you. So just make sure that if you haven't sent it in yet, that you are doing your medical and including it so that your application does not get rejected. They just made this change on the 2nd, so on Monday. They did not give us a heads up, and a lot of that's going to be happening in January, right? So they didn't give us a heads up. And unless you're like on the USCIS website all the time, you wouldn't know this. So if you are filing an I-485 and you need to include a medical exam, make sure that you are doing your medical exam and including it with your application, or USCIS can reject your application instead of just accepting it and asking you to then send them the medical. They will reject it, and then you have to still do the medical and then send the application in again. So that's just wanted to get that in because I know someone out there may be in the process of applying for a green card, and I want to make sure that you have this information. All right. So any new green card applications that are filed after December 2nd, on or after December 2nd. Wow. On or after December 2nd must include the medical exam, or USCIS may reject your application and basically force you to do your whole thing again. So I hope that was helpful. As always, if you like this video, go ahead and hit the like button. Let me know your thoughts in the comments. If you're watching this on the replay, thank you for joining me. Ask your questions. And if you want more information on my thoughts on mass deportation, on denaturalization, or on ways that you can get a green card without marriage to a US citizen, you can watch my last 3 videos. I go into those 3 topics in detail, so go ahead and watch those. And I will see you next week where you can ask me more immigration questions. Bye.